My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm is a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. The question that we're dealing with today is the circumstances under which someone can modify a custody agreement. Now, this presupposes certain things. The scenario here is we have a custody agreement. The parties did work it out. They either did it themselves or they got the court involved, and they had proceedings, and they had lawyers, and they have a bona fide court-ordered custody agreement, and it's supposed to govern the conduct of the parties. Now, for whatever reason, somebody wants to modify it. Well, you have to understand one thing. All that I just spoke about, all that effort that was made into getting a court order, it means something. It means something to the parties, it means something to the court, and while what it may mean may be different things to each person, some may be regarded as gold and some disregard it because they don't like what it says, to the court takes it very seriously. And that means that for the court to modify an existing custody order, it's got to have a really good reason why it should change its mind after all that it's already done. Now, don't make for a minute the mistake of thinking that, oh, wow, this probably never gets done. This gets done all the time. These modifications do occur, but there are certain circumstances that have to be in place for the court to do that. The first thing you got to realize is when you're modifying an existing custody order, the court won't even consider modifying such an order unless they feel that there's a significant and substantial change in circumstances that is occurring now that should even cause them to revisit the issue. So when the court first looks at whether or not they should do this, the first thing they look at is, do we have some kind of change going on? If the answer is no, or there is a change but it's not very significant change, the court's not even going to consider whether or not it should modify custody. So therefore, when you do this, your attorneys are going to put together first a petition to modify custody, and they're going to outline what the significant changes are. Significant change isn't that you don't get along with your ex. It's not that she's not letting you call the kid like she should. It's not that the kid doesn't want to stay with dad but would rather stay with mom. That is not going to cut it. When the court says significant change, what the court means is mom all of a sudden has become a drug addict, an alcoholic, lost her license, can't take the kid to school. The kid has become truant in school as a result of the parent not being able to do that. Those are significant things. And then the court might well say, you know what? We're going to have to check that out and revisit this issue because we don't like what's going on. That's the kind of thing, and there's a whole bunch more, where the court will say, all things put together, I see a significant change. Without a significant change in circumstances, the court won't even consider changing custody. And so those are the conditions under which the court might revisit the issue. If you have any questions about that, reach out, and we'll be glad to help you out.